Another big day on your front row seat to justice. Court TV cameras inside the courtroom for two major trials. In Kenosha, Wisconsin, the prosecution continuing its case against teenager Kyle Rittenhouse, who is charged with shooting 3 men and killing 2 during the summer of 2020 riots. Today, the surviving shooting victim took the stand.
Why didn't you take your own gun and shoot the defendant first?
Like I said, that's not the kind of person that I am.
We are in Kenosha with all the details.
Dramatic testimony from lone survivor Gage Grosskreutz takes over the courtroom. Jurors were riveted as he relayed emotional accounts from that night, but the defense scored huge points on cross-examination. Coming up, we'll break it all down.
In Brunswick, Georgia, day 2 of the shooting death of Ahmaud Arbery murder trial, and the officer who first responded to the scene testified about what he saw and what he heard.
Ronnie Bryan never told you that he tried to hit Mr. Arbery with his truck.
No.
We are at the courthouse in Brunswick with the latest.
Blood spatter evidence found on driveway pavement and a bullet hole through a nearby window. We'll have what the investigator testimony revealed and how the jury reacted.
On the docket tonight in Columbia, Missouri, the snake breeder murder trial. Lynn Lee Rennick accused of shooting her world-renowned snake breeder husband, Ben. We have a preview of the upcoming trial on Court TV.
Hearing that she attempted to poison him, all of that was new news to us. Finding out that she was having an affair we were shocked.
In tonight's Unsolved Case file in Buckeye, Arizona, 16-year-old Anaya Walker, a victim of sex trafficking, was found dead in a median on the road in May of 2020. Tonight, we ask for your help in getting justice for her family.
It's the most painful thing a mother could ever experience, is that I'm looking down at my grave, too.
This hour of closing arguments starts right now. I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. Great to have you aboard. 2 big trials that we're covering. And there was video today shown to the jury down in Brunswick, Georgia, in the shooting death of Ahmaud Arbery murder trial that we haven't seen before. Video that was shot at the time Ahmaud Arbery was being chased and followed through the neighborhood. First time we're seeing it. So we're going to show that to you coming up this hour on this program. But we're going to begin tonight in Kenosha, Wisconsin, in the other big case. This is the case against Kyle Rittenhouse, accused of double murder, accused of shooting 3 men during the riots in the summer of 2020. Now, as you know, I'm a former prosecutor. And as a prosecutor, I'm looking at this case and I'm saying, what is going on here? I'm in bizarro world. Because generally speaking, prosecutors, we have one obligation, right? And it's to get to the truth, okay? The facts are what they are. We don't change the facts. We don't try to shade the facts. We present the facts. We argue the law. That is it, okay? That's our job. Our job is to get to the truth. And when I say our job, I mean prosecutors. It's a much different job than criminal defense attorneys have. Their obligation is to their client. They're the defendant in the courtroom. And this isn't a knock on criminal defense attorneys about, the relationship between defense attorneys and the truth and prosecutors and the truth. It's just what our ethical obligations are. Prosecutors seek justice, which is the truth. Defense attorneys represent your client's interests. Period. End of story. It's that simple. But what is happening in Kenosha right now? And I think it's a real problem because juries can smell this. Anytime you as a prosecutor have problems with the truth, whether it's you or the witnesses you're putting up on the stand, that is trouble with a capital T. You cannot afford it. And in this case, we've talked about it in the opening statement. The prosecutor painted this picture of Kyle Rittenhouse chasing Joseph Rosenbaum and shooting him in the back. And I had an image in my mind. And then I saw the video, and it was like the exact opposite of what was described by the prosecutor. Okay, it may be, he's going to piece it together at some point, but that's not what I saw in the video. Then the eyewitness to the shooting, Richard McGinnis, takes the stand, and the prosecutor is attacking the credibility of his eyewitness. The eyewitness is going to say what he saw, right? The facts are the facts. Nothing you can do about it. Then today, Gage Grosskreutz, the shooting victim who survived, took the stand for the prosecution. Should be the star witness. Should be the star witness. But there were more problems today. Like problems with him not telling the truth to police and saying one thing when we're looking at videos that show something else. It's unbelievable. And as I said, it is trouble with a capital T for prosecutors. Let me show you an example. Here is some of the cross-examination of Gage Grosskreutz.
Toward the end of that large paragraph, you'd agree it says, sometime during the incident, my Gen 4 Glock 27 that had a belt clip attached fell off my waist, correct?
Correct.
Okay, that's a lie, right?
I wouldn't say that's a lie, no.
You didn't take the Glock out of your back here and run with it?
I did.
So it didn't fall off your waist, it was in your hand.
That's correct.
So you would say that's not a lie?
No, I would say it isn't.
Okay, and you told that to multiple officers, isn't that true?
I don't know.
The next sentence. I told multiple officers that I dropped my firearm, right?
Correct.
Okay. Now, you didn't drop your firearm. You were chasing Mr. Rittenhouse with your gun, right?
You
Yes. You were chasing him with your gun? Yes?
No.
You didn't chase him down Sheridan Road, pulling your gun, chasing after him. That's a lie. You're saying that didn't happen.
I'm not saying that it didn't happen, but I wasn't chasing the defendant.
You were running after him?
No.
No. During this trial, you're tweeting out, yes?
Yes.
And you tweet out to whoever these people are, make sure you look and listen for the defendant's firearm malfunction, and then you have a winky emoji face. Is that right?
That is correct, yes.
And you had said that you were looking for a non-lethal way to end this interaction.
That is correct, yes.
Yet you pulled your gun out and began, I'm going to use the word chase. You began chasing or running after a man who was running away from you, correct?
That is correct.
Now, you had said, and you were asked about the do no harm and the tattoo on your arm and things like that, right? You have some regrets from that evening, don't you?
No.
That's a photo of you, yes?
Yes.
Okay. That's Mr. Rittenhouse?
Correct.
Okay. Now, you'd agree your firearm is pointed at Mr. Rittenhouse, correct?
Yes.
Okay. When you were standing 3 to 5 feet from him with your arms up in the air, he never fired, right?
Correct.
It wasn't until you pointed your gun at him, advanced on him, with your gun, now your hands down, pointed at him, that he fired, right?
Correct.
Now, you had said you didn't have any regrets. Did you tell Mr. Marshall that your only regret was not killing the kid and hesitating to pull the gun before emptying the entire mag into him?
No, I never said that.
You didn't tell that to your roommate.
Objection, answer.
You didn't tell that to Mr. Marshall?
No, I did not.
Let me bring in Court TV legal correspondent Chanley Painter joining us tonight from Kenosha, Wisconsin. Chanley, great to see you tonight. Again, I always do this from where I'm sitting, right, which is watching this and then sometimes rewinding and watching again. This didn't seem like it went that well for prosecutors today with one of your victims or alleged victims, complaining witnesses, whatever we're calling them in the courtroom, surviving shooting victim, testifying today.
Right. Immediately out of the gate, this cross-examination took over the courtroom. Sparks were flying. You could tell everyone sitting on the edge of their seats, even the jury, raising eyebrows, going, okay, this is important. I'm taking pen to paper and taking note of all of this. Really, in the years covering cases on Court TV, this cross-examination, Vinnie, was dynamite sitting inside the courtroom. And this defense attorney doing a fantastic job. You could tell he was well prepared in trying to hold Gage Grosskreutz feet to the fire, impeaching him on his police statement, his testimony today, and really scoring some huge points for the defense.
It was, and inside the courtroom, how does it work when you've got the witness and you've got the video going up at the same time? I mean, some of the things he said just seem to be the exact opposite of what we have seen. Does the jury look at both? Like, is the picture of him pointing the gun at him up while he's testifying about that? Is the video of him running, I guess, towards Kyle Rittenhouse? He's not saying he's chasing him. The jury will figure it out. But running in that, is all that being played for this jury at the time that he's saying, no, that's not happening?
This defense attorney is doing that. He allows the witness to first answer the way the witness wants to answer, and then he will put the picture or the video or the statement in front of the jury on two huge television screens and pause it at certain points, and then the witness would change his story and agree with the defense. And on recross, he did eventually agree and say that, yes, he was chasing Kyle Rittenhouse down the street, who was running the opposite direction, and he had a loaded gun with a bullet in the chamber. He did finally agree to that later on in the recross examination. But the moments that you say that the defense attorney was able to put on the screen, the still photos, it was powerful, especially the part where he paused the video to the picture where he gets Gage Grosskreutz to admit that the position his body was in after he raises his arms to Kyle Rittenhouse, but then Kyle is on the ground. Right the moment that Kyle shoots Gage Grosskreutz, is your gun pointing at the defendant? And he agreed. And that was the moment you could really tell in the jury that, okay, and they wrote all of that down, Vinnie.
Let's get some reaction from our think tank tonight. Stand by, Chanley. Joining us in Fort Lauderdale, Florida, criminal defense attorney and civil rights attorney Casey Early. In Atlanta, Georgia, criminal defense attorney and former president of the Georgia Association of Criminal Defense Lawyers, Lawrence Zimmerman. And also in Atlanta, criminal defense attorney Michael Bixson. Great to see everyone tonight. Casey, tell me your thoughts about how this is going for prosecutors. And I'm a former prosecutor. I'm looking at it, I'm like, I would not feel good right now. And when I've got one of my shooting victim up on the stand and seemingly kind of not stating things that are obvious to me when I look at the video.
Not at all. This is zealous advocacy at its best. The defense attorney came in and he did his job. He went and attacked the credibility of what I would say would be the prosecution's star witness. And what baffled me from the beginning was, why did the prosecution bring out the bad facts? I actually fell in love with the witness. He was credible on direct examination, and then they just attacked what was obvious to the prosecution. Why not bring out the complaint? Why not provide an explanation? You cannot rehabilitate that witness once his credibility was destroyed. So, I mean, the defense did an excellent job in bringing out those points that would show his bias in his testimony, that he was the aggressor, and he was not, in fact, backing up and trying to, keep the peace, but he was being the aggressor, and Kyle Rittenhouse had no other choice but to shoot him. So excellent on the part of the defense.
Lawrence, there's no doubt. I mean, he sustained a horrific injury, right? Anthony Huber lost his life. Joseph Rosenbaum lost his life. He had his bicep was obliterated, and we see it in that gunshot. He's got a $10 million lawsuit, but the jury didn't find out about it until cross-examination.
Well, yeah, I mean, that's kind of ridiculous. They should have brought that out on the direct, and they should have talked about it. It would have lessened the blow. I mean, it's pretty shocking to hear that on cross. Oh, you have a lawsuit for $10 million. That's a bad job by the prosecution, Vinny.
Yeah, very problematic. Michael, I want to show you something here. This was another point where I was like, why is he answering this way? Talking about the gun and him pulling the gun out. Take a listen.
He tells you he's running, and he tells you whatever he tells you. I'm going to the police, or what you think is. He pulled the gun first, and he's running away from you, right? He's running north on Sheridan Road. Yes?
Correct.
And he's running away from where you're standing. True?
Correct.
You at that point pull a firearm out from your belt and begin to chase him. True?
That is not true.
I want the picture. I'm going to show you what has been marked as Exhibit 35. Can you take a peek at that for a second? That's a picture of you, is that right?
On the right-hand side with the blue cap and... Yeah.
You can look there where this is you, right?
Correct.
Okay.
Michael Bixson, he said no when he's asked the question. There's a picture of him, video of him going behind his back, grabbing the gun. I don't understand this. And I just feel like, and you know, this is not necessarily the prosecutor's fault, but it ends up part of your case. This is your witness, your victim, your complaining witness, whatever we're going to call him in the courtroom. But he's saying one thing, and the video is telling me something else.
I don't know, Vinny. I mean, it's hard to say whether or not this really is or isn't the prosecutor's fault. I mean, I put a big part of it down to their preparation of their witness. And I think if they had spent more time preparing him and explaining to him that maybe not, maybe not being combative to everything that he's being asked, maybe that's not going to put him in the best position, because it's clear. You look at the video, you see him chasing him, right? Or pulling out the firearm. These things are, you could see him clear as day. There's not much of an issue here. But when he starts lying or being combative with the, defense counsel, I definitely think you're going to start running into issues for the prosecution. And I definitely think they are because of it.
Lawrence, do you think he got advice from his civil attorney, and I don't know who his civil attorney is, but said, got to be careful, we can't say this, we can't say that? Because this is a complaining witness who hasn't really cooperated with investigators. He didn't speak with them, he didn't tell them his story, he didn't let them look at his phone. They wanted to take a look at his phone, he said no. He's acting more like a criminal defendant in his relationship with investigators here. And I'm not saying that he's a criminal, but that's the way he was acting, his reactions to everything. Not like your classic shooting victim.
Well, Vinny, I mean, isn't there the inherent problem in this case where you have all this lawlessness and all these different men running around with guns like it's the Wild West and it's just chaos? I mean, this guy has a gun, he's chasing after people too. I mean, it's just nuts. I mean, I think everyone seems to have a gun here. Of course it's chaos. And is anyone shocked that people were actually killed by somebody this night? I mean, and to your question, though, I mean, yeah, I'm sure in his mind he's trying to be very careful in his answers, probably thinking through everything he says, because he doesn't want to affect a potential $10 million windfall for getting his bicep blown off when he was chasing after somebody in Kenosha.
Yeah, and again, I'm not minimizing his injuries, and I'm not minimizing the death of Anthony Huber or Joseph Rosenbaum. The defense here is self-defense. So the defendant is saying he is the victim of all of this, and the jury has to figure it out. But right now, it is not a great spot that prosecutors are in. Can they still win it? Oh, maybe. When we come back, the think tank's with us the whole hour. But when we come back, we'll take a look at the redirect. Right after your witness gets cross-examined, you have an opportunity to put them back on the, or to question them again, to try to bolster their credibility and fill in the blanks, let them expand on some answers so you can regain the credibility of that witness and your case in front of the jury. We'll show you how that went next.
It was my interpretation throughout the events of August 25th that these armed individuals, whether they were Boogaloo Boys, Proud Boys, etc., all had we'll say a homogenous appearance. Again, meaning the rifles, the body armor. And what I had inferred throughout the events of that night, that these groups of people weren't received very friendly towards other demonstrators. And in specifically to reference the defendant, it was also my interpretation that the defendant lacked the necessary experience, potentially the necessary knowledge to adequately fulfill his self-proclaimed role as a medic.
The Boogaloo Boys, the Proud Boys, you know, protesters. It was chaos. It was chaos in Kenosha, folks. That was part of the redirect of Gage Grosskreutz. Let's take a look at another point of this redirect where he gets up from the witness stand and stands right in front of the jury to demonstrate what exactly he was doing. And it's interesting because we've seen it on video and we've got still pictures of it, but he's doing the demonstration anyway. And he's very comfortable. I mean, he's got the microphone in his hand doing the demo. Let's see how it went and see if it made any difference.
Would you mind, if you can, standing up and demonstrating to the jury how your body is positioned in this still?
If the defendant is right here in front of me on the ground, this is my pistol that I had in my hand, my cell phone. My body is bladed towards the defendant. I have her cell phone in my left hand, microphone or pistol in my right. My body is bladed with my left hand, left arm, towards the defendant's firearm, with then my pistol in a similar angle I'm about to show you.
At that moment in time, right before you got shot by the defendant, did you feel there was an imminent danger that the defendant was going to kill you?
Yes, absolutely.
When you were just demonstrating to us the way your right hand was holding the gun, however it was angled, my question for you is that the way you hold and point a gun when you're going to shoot it?
No.
Okay, and he didn't fire the weapon. He didn't fire it. But he pointed it. So you've got two guys pointing guns at each other, right? I think they're both kind of in fear. I mean, everything he's explaining for Gage Grosskreutz. I mean, Kyle Rittenhouse is in the same position at that moment as Grosskreutz is, right? They're both, it's a standoff. They both got guns. It happens very fast, but they're both pointing guns at one another. I'm sure they're both scared. Let's bring back in Court TV legal correspondent Chanley Painter, who is in Kenosha tonight. Am I reading that right? That at the moment that he's describing, they're kind of both in the same position at that one moment in time.
Yeah, I believe you are. And it was a poignant moment when Gage Grosskreutz left the witness box and demonstrated him. He's directly in front of the jury at that point, demonstrating that positioning. And when he was asked, is that how you would hold the handgun to shoot it or point at someone? And he said, no. That clicked with the jury, Vinny. It did, and they wrote that down. And so it was a rehabilitation of this witness, and the prosecutor was able to make some of those strong points, including the fact as to why Gage Grosskreutz would start running in the direction, not chasing, but running towards Kyle Rittenhouse. And that was made clear by the fact that he heard people calling for a medic, and he explained that's why he started running in that direction to try to help. And so again, some points made there, but every time a witness leaves that witness stand, that's a moment that any jury really will pay a lot of attention to.
Absolutely. And you know, will the jury make a distinction between this is not how I hold the gun when I fire it versus it's pointed in that direction, and should the defendant know that? Is it reasonable to think that he's in danger at that moment? That's their question that they have to answer. He also testified, though, didn't he testify that he made the decision to close in on Rittenhouse at a certain point?
He did. He made that decision. He said that was the moment. He had his hands up, put him down. That's when he described Kyle Rittenhouse re-racking the gun and what he perceived, Gage perceived, as a malfunctioning of the weapon. And that's when he felt like, okay, this person's not accepting that I'm surrendering with my hands up. And he said that's when I decided to move in closer towards him to try to prevent myself from being shot with that weapon. And of course, at that moment, he was shot. So yeah, that's how he explained why he was moving closer to Kyle Rittenhouse. And you're right. It's what will this jury, is it what's in the mind of Gage Grosskreutz or the mind of Kyle Rittenhouse here that they have to judge, Vinnie?
Absolutely. Okay, let's bring back in the think tank. Michael Bixson, I want to ask you, will the jury make a distinction between this is not how I hold my gun when I'm about to shoot it versus it's pointed at the defendant? Is it a threat? Is it not a threat at that moment?
Vinny, it's on the video. I mean, it's clear as day. He's pointing the gun at him. I mean, you can take him and have him demonstrate to the jury how he was actually holding the gun and hold a microphone and sort of walk it through. But you can watch the video. You can see it clear as day. He's pointing the gun at him. I mean, I don't know much more clear you can get, and you can try to rehabilitate him all you want as a witness, but there is no escaping that devastating cross-examination.
Casey, there are three counts here, right? Three, again, I keep wanting to say victims, but the judge isn't allowing that in the courtroom, but I'll use it here to say there's three shooting victims, right? Two lost their lives, and one who testified today was shot in the arm. So let's just deal with the one who was shot in his arm, Gage Grosskreutz. At this point, is this a reasonable argument for self-defense?
It is and it isn't. I see both sides. I know that right now the jury is probably thinking, okay, that picture where the still frame of Mr. Grosskreutz pointing the gun, that is a reasonable explanation for self-defense. But at the same time, I can see the other side. The other argument is that he was going to shoot him, and Kyle Rittenhouse shot first and disabled that arm, which did not allow Mr. Grosskreutz to shoot back. Because if I saw that correctly, that arm that he shot his biceps, that was the same arm that was holding the gun. So he was unable to shoot. So at this point, it was who shot first, right? So had Mr. Grosskreutz shot Mr. Rittenhouse, he could have claimed self-defense as well. So it comes down to credibility. And again, his credibility was destroyed on cross-examination.
Lawrence, is this, I mean, under what scenario you have two people who don't know each other pointing guns at each other? At what point is it, under what circumstances would that not be self-defense? If there's two people who don't know each other that are pointing guns at each other?
No, I'm with you. I mean, listen, it's like if I walk into Walmart and there's a guy carrying AR-15, he's not pointing at me, but how do I react? I mean, there's been shootings in Walmart. Or is it self-defense if you shoot the guy? He's open carrying AR-15. You don't know the person's intent. And here again, you have all this lawlessness. Rittenhouse is on the ground, and there's gunfire going on. It's hard to really tell what's going on. For Rittenhouse doesn't know this guy who's going to shoot him, and then I can't even pronounce his last name. I apologize. Is he where Rittenhouse is going to shoot him? So to me, in this scenario, it looks like self-defense. I'm sure somebody will come back from the police and say, well, you really can't tell by pictures of what exactly he was doing because pictures don't tell a whole story, which cops say all the time in prosecutions to try to get around video. But clearly, if this guy's pointing a gun at Rittenhouse, whether it's directly at him, he's certainly close enough for Rittenhouse to be in fear for his life. So I guess maybe tie goes to the runner, and Rittenhouse is the one who's on trial, so he wins on that count.
All right. Think Tank staying with us. When we come back, we're going to take you down to Brunswick, Georgia. Julie Janae, down there, Court TV legal correspondent. The latest, including some new video that was shown in court today that you haven't seen yet. The shooting death of Ahmaud Arbery when we return. Welcome back. If you're busy, like you're distracted right now, you got to stop. You just got to sit down and just pay attention for the next 10 minutes or so. We've got to get through some very heavy lifting in what's happening down inside the courtroom in Brunswick, Georgia, the shooting death of Ahmaud Arbery murder trial, because there are some legal issues that are a little bit confusing that are taking place. It's not the easiest stuff to deal with. So we've got experts that are going to deal with it, but let's start here. Glynn County Police Officer Ricky Minshew testified today. He responded. He had a body cam with him, but he's on the witness stand, and watch what happens. This is not what you would expect to happen. Take a look.
Did Brian ever talk about whether he should have been chasing Ahmaud?
He did.
Okay, and I'm going to ask you to turn to page 20, lines 23 through 24, and just tell us specifically what did Mr. Brian say in terms of...
Could you give me the lines again?
Sure. Lines 23 through 24 in terms of Mr. Brian's involvement.
All right, and one more time for the page.
Page 20. I'm sorry.
Okay.
Might be going a little bit too fast.
23. He said, I mean, this would have never happened, you know. He said, I mean, this would have never happened, you know. Should I have been chasing him? I don't know.
So you've got the responding officer reading a transcript from his body cam. We have the body cam, like we have it here at Court TV. I've shown it to you plenty of times in the buildup and over the course of the last year. Let me show you. What he was just reading is on camera. It's recorded on video and audio. Take a look.
Where is the shotgun located at during this? While the black guy was punching, you said the black guy was punching the white guy in the face, right? In the head?
Yeah.
While he's punching him, where is
Most of the time it's down like this.
Okay.
And Travis really can't get away from him, can't pull up with the shotgun. I think Travis even gets a lick or two in.
Okay.
And the other black guy gets another lick or two in. And about that time, the shotgun gets raised up, and he pulls the trigger.
Okay.
And then it seems like it goes for a second of struggling again.
Okay.
I mean, like, good 10 seconds maybe.
Okay.
Before again. I think I heard three shots.
Was he defending himself? Did it look like he was defending himself to you?
Yeah. I mean, if the guy would have stopped, you know, I mean, find out what was going on, he obviously was up to something. I mean, this would have never happened. You know, should we have been chasing him? I don't know. I mean, but, yeah, no, at that point one time when I cornered him up over here, he was trying to get my truck.
And I saw a lot of messages and posts on social media. People, why are they reading the transcript? Why aren't they showing the jury the body cam video that we've all seen? Let's bring in Court TV legal correspondent Julia Janae, who's live in Brunswick, Georgia tonight. Julia, let's start. This is the tough part, right? We got to figure out exactly and try to understand and explain why this jury is listening to an officer read a transcript when we've got a video and an audio of everything that he's reading.
This was a decision by the prosecution. They say they are trying to avoid the legal landmine that is the Bruton rule or the Bruton case. That essentially, because they chose to file this case or indict this case jointly, and they are going after 3 co-defendants who all gave statements to police, there's the possibility that those statements could be incriminating. And we know that each one of those defendants has the right to remain silent, to not take the stand and then be under cross-examination by those other attorneys that are in the room. But if these incriminating statements come out, there's not the opportunity for these other defendants to then cross-examine that person if they don't take the stand. So to avoid violation of their Sixth Amendment rights and the Confrontation Clause, they are not, or the prosecution rather, says that they are trying to avoid putting in that video. Their remedy for all of this was to get an agreement with the defense before the trial to say what statements they would be putting in and that they didn't plan to play any of the body cam video, but that they would put it into evidence for the record only. But it didn't seem like that was the way things worked out once trial started. Take a listen to Prosecutor Dunikowski after the defense said they now want to play that video.
The state feels, having had an agreement from the defense, that all of a sudden we've tendered it into evidence with the purpose of making it part of the record and with our intent clear that it was not going to be played. And now, of course, Mr. Sheffield's telling me, oh, no, it's tendered into evidence. It's in evidence. I'm now going to get to play it. So the state, of course, feels a little hoodwinked, bamboozled, that I had an agreement with the defense attorneys as to what the nature of this was and our intent to just make it part of the record. Now, if that was an error on my part to be so transparent and forthright and to try and work with them, and I shouldn't have had this tendered in, and I should let them go ahead and tender the body cam in to then show portions, I understand. And I would understand the court's ruling at this juncture if it's in and they want to play portions of it, then that's on us for having attempted to do the right thing, and we'll go down that path.
A really sticky issue, Vinnie, where the defense was able later in the day to put in some of those portions, but the state, it seems, was really trying not to be the ones to tender that evidence to allow the defense to then, on cross-examination of their own witnesses, to bring in that body camera footage.
All right, let me bring the think tank, because I think there's more to this story. I mean, the prosecution is saying it's a brutal issue. I don't want to use a statement by one defendant that incriminates another one, because then they can't cross-examine that statement made. Lawrence, is that what's really going on? Or is it that prosecutors don't want that body cam in front of this jury because each of these defendants basically lay out their entire story and their defense in those statements? They tell their whole story without being cross-examined.
Right. I think Ms. Donikowski's being not hoodwinked. She's trying to pretend she's hoodwinked and playing it the other way. You heard Rodney Bryant say what Travis Michael is doing, who's acting in self-defense. He sounds more credible on a video than he does with a police officer stumbling through the transcript and reading it. So, yeah, that's absolutely what's going on. I mean, look, it's a sticky situation when you charge 3 people and you have brutal issues. I've had to have cases severed. Maybe the judge should have severed the case, but because they don't want to try this case 2 or 3 times, not going to. But it creates appellate landmines, and the cases get reversed for these issues. So you're leaving out important pieces of testimony. And, Donikowski likes it better this way because it sounds better for her. And that was the argument earlier about rule of completeness. We don't hear the whole statement, and you got to play it. She's hoodwinking the judge and saying that. My closest friend's Paul Camarillo is the other prosecutor, so I won't say anything bad about him ever. But this is not the way to do it.
Casey, early, should the jury see the entire body cam with each defendant basically telling their story without being cross-examined?
If that's a defense strategy, I say play it. I mean, this is adversarial for a reason. And I understand that there was a stipulation in the beginning and she feels as if the defense pulled a wool over her eyes. But at the same time, a trial is growing. I mean, you don't know what's going to come out in direct or cross-examination. So possibly this was a strategic move. And I agree with my colleague here that it sounds better from the defendants themselves telling their story right when it happened, as opposed to hearing someone else read that transcript without the tone or how it was said at the time. So I don't think that they were trying to, have this issue with the prosecutor, but play it, and maybe this avoids the defense or the co-defendants from taking the stand and testifying.
Yeah, Michael, from where I'm sitting, like I said this in the beginning, I said if I was the prosecutor, I would do everything I could to keep that video out, because if these defendants are going to say self-defense, I want them on the witness stand live in front of the jury, and I want to cross-examine them. I don't want to turn this into the George Zimmerman trial, where George Zimmerman told his story and was never cross-examined by anyone. It was on video, and for some reason, prosecutors played it in that case, and it looks like it's going to end up being played in this case.
Absolutely. I mean, if you're a prosecutor or any attorney for that matter, you want to play the snippets that help your case, not hurt it. So having an officer read certain portions of it obviously is much more preferable than playing the whole video and hearing the defendants tell out their story for themselves. So it makes sense, obviously that the prosecution wants to keep that whole thing out and that they're arguing against it. I totally understand their position. For the defense, it absolutely makes sense to try to get that video in to tell their client's story without having to put them on the stand. So from both perspectives, I understand where they're coming from. However, I do think that they should be able to get at least portions of that video in.
Yeah. At the end of the day, if these defendants, if that body cam comes in, it's advantage defense if they see the whole thing, just because now they don't have to testify. Because what they say in the video is exactly what they would say on the witness stand on direct. What we don't know is what they would say on cross-examination. All right, when we come back, wow, Roddy Bryan, the one who shot that video. You haven't seen the whole video yet. When we come back, you will see the part that has been hidden since the beginning of this case until today. Don't go away. All right, folks, today they played the video of Ahmaud Arbery being shot. I'm giving you the warning up front. I'm going to play it for you now. It includes some portion of the video that we never saw before. Let's watch.
Yes, one night.
Court TV legal correspondent Julia Janae still with us. Julia, reaction inside the courtroom to this video?
Really just intent stares from these jurors. They are watching it intently. There's a lot of video that they've seen today, and there were times when they were moving forward in their seats trying to make sure they could see it. You can tell that they are very dialed in to making sure that they are taking in all of this evidence. They're sitting in different places in the courtroom, and anytime there's something that they can't see very well, they're going to raise their hand. They're going to let the judge know. So this was another tough moment, not just for those jurors, but of course for even those in the gallery having to watch this.
All right, I want to bring back in the think tank, and as we talk about this, I'm going to play the beginning part that we haven't seen before. It'll be slowed down a little bit, but Michael Bixson, is this the whole case or just a piece of the case for prosecutors?
I think this is a very big piece of the case for the prosecutors. Any video that shows the McMichaels chasing him down in the trucks, I think it's terrible for the defense. It's great for the prosecution. Anything that illustrates, this long pursuit, I think is absolutely going to help the prosecution.
And this shows, Vinny, from the very beginning how the aggression just never stopped. That not only did they hunt him down, I mean, it just showed that Roddy and the McMichaels, they had consistent involvement throughout this entire time, especially Mr. Bryan, who's trying to distance himself. This actually places him there for the entire time.
Lawrence?
I disagree with both my co-counsels on this court TV program. The fact that Roddy Bryan actually videotaped it, I've been saying for last year, that actually helps the defense. So you wouldn't video something that you knew someone was going to be shot at the end, or if you're intending to murder them. I always thought that was very helpful. And where's the phone calls between Roddy and the McMichaels before, after, during? There's nothing. He just followed with the camera. This happened, and
it's not the phone calls. It's the fact he was recording it because he knew that his actions, or in his belief, was going to be justified, but it did the complete opposite. It showed them as the aggressive killers that they are. So he, in his mind, thought, okay, I'm doing something right and I'm going to film this. Not at all.
Well, but the fact that he filmed it showed he had no intent himself. I mean, that I believe is helpful. And listen, and if you listen to Bob Rubin's opening, which was fantastic in my opinion, I'm sure it'll come to fruition. Mr. Arbery is what, on a dock one night in the back of a house, or 3 other times he's out there. He's throughout this whole neighborhood.
Gotta
And so
leave
if
it
they had
there.
cause to believe-
Casey, Lawrence, Michael, thank you so much. We'll be right back.